Last time, we looked at the emergence of legal positivism in the West and the influence of thinkers like David Hume and Jeremy Bentham. We looked at how the attempt to reform the law by detaching it from morality and making the state the sole source of the law ended up paving the way for the modern total state. The law is what the sovereign, the legislature, the state says it is. The effect was probably inevitable. Power has been centralized like never before in history, and even so-called democratic countries have lurched inexorably towards greater authoritarianism. With the state as sole authority to make law, unquestioned, there has been an explosion of laws, statutes, and regulations that few ever read and fewer understand, clogging the arteries of the modern state. As Tacitus wrote, "The more corrupt the state, the more numerous the laws." But if the law is what the state says it is, isn't the real power in the hands of the judges who interpret the legislation and regulations that the legislatures churn out? Welcome to the doctrine of legal realism, which emerged in the early 20th century, and also welcome to its most eloquent proponent, United States jurist and Associate Supreme Court Justice OIiver Wendell Holmes, Jr. Holmes' pragmatism is illustrated in his famous quote, which I put up in full at the start of this video. This is from the 1927 U.S. Supreme Court decision in Buck and Bell, which upheld Virginia's sterilization laws. In his majority decision, Holmes quipped, "3 generations of imbeciles is enough." We in 2024 may well appreciate the negative consequences of a society filled, and indeed led, by imbeciles. But Holmes' impact on our lives goes well beyond eugenics, which seems to come in and out of favor, depending on who is in power and who is, at any point in time, the target of a cull. Yesterday, it was the rural inbred. Today, apparently, it's rich boomer whites with families. In Canada, the federal bureaucrats reassure us that although 50,000 or so Canadians have been euthanized since 2020, under Canada's very generous medical assistance in dying legislation, or MAIDs, don't worry, those prescribed this ultimate remedy are mostly old, rich whites anyway, so no harm done.
People who are getting MAID are actually very, very privileged. They're white, they're well off, they're highly educated, they're not in institutions, they have families.
OIiver Wendell Holmes, Jr., born on March 8, 1841, was an American jurist who served as an Associate Justice of the U.S. Supreme Court from 1902 to 1932. He retired at the age of 90 years. Holmes is one of the most widely cited Supreme Court justices and among the most influential American judges in history. Holmes opposed the view of law as a broad, abstract concept and attacked the proposition that all legal provisions could be rationally defended according to some conceptually deductive process. He saw law as indeterminate. He didn't believe you could find the law by your reason and appeal to something rational out there in the universe. He was a moral skeptic as far as the law is concerned. He didn't think there were objective standards that can determine right and wrong. This stands in stark contrast to theories of natural law that I covered in previous videos. The truth was definitely not out there for Holmes. Since laws were indeterminate, judges had to rely on their personal and political preferences to make decisions. Legal realism has a close kinship with legal positivism. Both agree that law is constituted by social facts, that judges have and exercise significant powers to make law, and that a law is morally fallible, and so is to be approached in a realistic spirit, in the everyday sense of that term, without what they saw as romanticism or mystification. There are 2 main schools of legal realism, the American and the Scandinavian. In this video, I'm only dealing with the American kind, which differed from legal positivism in rejecting an assumption, which most people have to this day, both trained lawyers and lay people alike that laws, in the form of legislation, regulations, and even legal codes, determine the outcome of legal disputes. Legal realists reject the idea that these written laws create normative standards to which the facts of the case can be applied to predict an outcome. Law is a social construct to legal realists, and is in reality only what the judges think or want it to be. The law isn't what you read in that statute, but exists only in its application, in action, in court, where judges are agents of social policy and are not bound by pre-existing legal rules and concepts. Legal realism is the philosophy of pragmatism, which captures perfectly the peculiar American attitude to life after World War I, one that envisaged the search for truth as a continuous experiment to find out what actually worked. The hell with high principles, with a reverence for practical achievement above all else, what William James called, derisively, the pursuit of that bitch goddess success. Legal realist thinking remains prevalent in modern society today, inspired by the social sciences. Realists are modernists and progressives, one notch up from legal positivists. Legal realists were probably the first to express their fascination with law as having as its primary reason for being a progressive social function and purpose. The Ciceros and natural law thinkers were just high-minded fools, hopelessly naive and impractical. Law is not about the good, right, and justice. Law is no different from any technology. It is a way to get things done. If the judges don't like the words of a statute, they just ignore it. When the English judiciary decided they didn't like the 1961 Suicide Act, which made it a crime to accompany a terminally ill person to an overseas euthanasia clinic, they just refused to implement it. This is why legal realism is sometimes described as judges reasoning backwards. First, a judge looks at the case in front of him, the parties and the social facts underlying the dispute, and consciously or unconsciously decides who is going to win and how he's going to rule. The judge then reasons backwards to find and interpret and twist whatever written laws supposedly control things to get the outcome he wants. The reasons are then delivered, this time from forward to back, giving the impression the decision arises rationally and logically based on the interpretation of laws and precedent or past decisions of other judges. But really the fix was in all along. That's not a bad description of how courts seem to work, especially in the progressive activist woke courts of the West today. As for law schools, they are highly influenced by the work of sociology departments and do not even pretend that the function of the lawyer or judge is anything else but to be agents of progress towards greater equality, equity, and inclusion. If the case involves a tobacco company, a member of a politically hated group, or a plaintiff from a recognized victim community, you can generally predict the outcome, even though it may be harder to predict exactly how the court will get there. That is often the surprise, how the result is justified. This is exactly the language Holmes used in his famous paper, The Path of the Law, published in the Harvard Law Review in 1897. He wrote that the object of the study of law is prediction of the incidence of the public force in the form of reward or punishment through the instrumentality of the courts. The best way to do that is to look at the law as a bad man who cares only about the material consequences of his actions. For this reason, jurists like H.L.A. Hart have called the legal realists rule skeptics. A recent example of this would be Trump being struck off the ballot in Colorado by a court made up of Democratic Party judges, who somehow come to the conclusion that Section 3 of the 14th Amendment applies to a presidential candidate, even though the provision by any fair reading clearly does not apply to the presidency, and that Trump was guilty of insurrection, even though he has never even been charged, let alone convicted of insurrection. Another example would be in Canada, where the Chief Justice of the British Columbia Supreme Court declared publicly that every judge in British Columbia was vaxxed, even though he was under no legal obligation to make that public pronouncement, and then proceeded to dismiss every case challenging state action during the lockdowns. I would say all these results, and many others like it, were predictable. Those who labor under a purely positivist, classical liberal understanding of the law still expect rules to be applied by the courts in a normative way, as if they really controlled what judges do, and are continually surprised when they lose. They fail to appreciate the political aspect of judging in the West today. But is that the basis for determining, as Holmes does, that these decisions are law? Isn't this the exact opposite of law? Do the bad decisions of activist courts really refute natural law theory, that there is a true law out there? Holmes warned against viewing the law from the perspective of the good man, who was controlled by vague sanctions of conscience, and seems to have built his worldview of law on his own world of appellate court advocacy and judging, which was fact-oriented and context-specific. He also ignores law in action outside a court setting, laws that people obey without question, all the time because they think they're reasonable. Courts, on the other hand, are constantly forced to formulate policies that balance conflicting interests of different classes and ideologies. But does the application of law in a anarcho-terrorist state, where the same laws have different consequences depending on whether you are politically favored or not, does that have anything to do with what the law really is? Legal realists, or some of them, convolute two entirely different things. It isn't surprising that a kind of legal realism emerged in the U.S., which inherited the common law tradition of judge-made laws from England, combined with the litigious nature of American society. Unlike the civil law system in continental Europe, based on Roman law, where judges are little more than clerks managing the civil code, and the advocate or lawyer is the real star, in the common law system it is the judge who holds center stage on a high pedestal and is the fountain of law, as they say. It was inevitable in a country with a Supreme Court charged with making and striking down laws that the idea that the law is really just what the judges decide would emerge. But anyone who has practiced law knows that advising clients is about two different things. First, you give a client your opinion on what the law is, or what the law should be, as interpreted by a just court. But then you have to tell the client the risks of proceeding to trial, and all the various ways a court might rule against them, and why. Often these risks have nothing to do with justice, but quite the opposite. You will outline the biases and prejudices that could stand against them. This can be confusing to some clients who assume that if they are in the right, they must win. That is not at all certain, and the clients need to know that there are bad judges and fickle juries out there. Losing to a bad or biased judge, or a dim-witted jury, is a risk that has nothing to do with the law. And that is the point. There is a distinction between what the law is, or should be, and what may be decided by a judge or jury for completely irrelevant or even irrational reasons. Legal realism confounds the true law, a very real thing we can find with clear thinking and our rational minds, and the assessment of risk and the possibility of bad decisions. Roe v. Wade is only one example of bad law that took literally decades to reverse and could be reversed again. That doesn't mean there isn't an absolute and correct result on the issue of, for example, abortion, based on principle that the broken clock of the judiciary gets right every decade or two. As Brian Leiter writes, legal realism is not a claim about the concept of law, but rather a claim about how it is useful to think about law for attorneys who must advise clients what to do. From the practical perspective of the franchisee, what one wants to know about the law is what, in fact, the courts will do when confronted with the franchisee's grievance. That is all the law that matters to the client, and that is all, I take it, the realists wanted to emphasize. What we can see then in legal realism is a very backward step, a final rejection of any moral restraints on the law, and towards the modernist activist courts and legislatures of today. Legal realism opened the way to thinking of law in purely functional political terms. It very clearly paved the way for critical legal studies, another manifestation of the better-known critical race theory, and the view that the law, like everything else that matters, is just about power and politics. Rules, rights, objective truths are merely tools and do not exist independently, and can be tossed aside when they interfere with the political objective. The legal realists didn't go that far. They were more about psychology and social policy, and were certainly not Marxists. But in dismissing the restraint of morality and the idea of a natural law, they had thrown the door wide open now for the modernist, woke, progressive crowd and their pillaging cohorts. In Holmes' Path of the Law, we see very clearly the modernist agenda in a very early form, his dislike, even disdain for tradition and custom, for the teachings of ancient jurists and legal philosophers, and an attraction to what would later be called technocracy, scientism, and progress towards a perfect materialist understanding as to what the law's function and purpose should be. He writes, "For the rational study of the law, the black-letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. It is revolting to have no better reason for a rule of law than it was laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past." Holmes imagined a law stripped of all the language of morality, although he acknowledged that would be difficult. He saw moral language as clutter. If he predicted anything, he predicted a world stripped of the moral context of action. Everything from addiction to murder. All was capable of being understood and explained scientifically. His solutions are very 19th century, like the noose, but one can see how we got to the therapeutic state through the doorway he opened. But the inquiries which have been started look toward an answer of my question based on science for the first time. If the typical criminal is a degenerate bound to swindle or to murder by as deep-seated an organic necessity as that which makes the rattlesnake bite, it is idle to talk of deterring him by the classical method of imprisonment. He must be got rid of. He cannot be improved or frightened out of his structural reaction. If, on the other hand, crime, like normal human conduct, is mainly a matter of imitation, punishment fairly may be expected to help to keep it out of fashion. I look forward to a time when the part played by history in the explanation of dogma shall be very small, and instead of ingenious research, we shall spend our energy on the study of the ends sought to be attained and the reasons for desiring them. Holmes seems to have believed that by dismissing all of what he regarded as sentimentality about tradition, and disentangling law from morals, and sticking to some kind of scientific inquiry into how law really worked, we would somehow discover, and I quote directly from the last line of Path of the Law, discover a hint of the universal law. This is an interesting choice of words, as it suggests a belief in a kind of natural law or natural order at work, but one that was entirely mechanistic. Viewed from the perspective of 2024, Holmes, and I quote, step towards that ideal, end quotes, must be viewed as a great leap backwards from the good, the virtuous, and the just, which is what the natural law he rejects was really seeking. Holmes, unbeknownst to him, was ushering in a new modernist dark age, a legal war against our very humanity, in which the soft, corrupt science of sociology would rise triumphant. Systemic evils would replace real inquiry, and progressive agendas would be uncoupled from any moral or legal restraint.
Then something really wrong is going on.
Mr. Kirkland, you are out of order!
You're out of order! You're out of order! The whole trial is out of order! They're out of order! That man